Tony DeWitt here, Missouri Appellate Attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. So today is day 5, and today we're probably in Puerto Limon, Costa Rica. Today is a beach day, and we're sitting out there under the sun, and I hope you're staying warm here in the United States. So one of the questions that I had from someone suggested that how fees are set up for lawyers would be a good topic for a video. So today we're going to talk about legal fees. So let's start with the lawyer's ethical rule. And it says that a legal fee must be reasonable. And here is what the rule says. This is from the Missouri Rules of Court. It says, a lawyer shall not make an agreement for charge or collect an unreasonable fee or an unreasonable amount of expenses. The factors to be considered in determining the reasonableness of a fee include the following: the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. 2, the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. The fees customarily charged in the locality for similar legal services, the amount involved and the results obtained, the time limitations imposed by the client or by the circumstances, the nature and length of the professional relationship with the client, the experience, reputation, and ability of the lawyer or lawyers performing the services, and whether the fee is fixed or contingent. So that gives you a general idea of what most lawyers are required to do with respect to fees. In addition to the factors set out in the rule, I would point out that the geographic locale and the type of court also figure into this. It's reasonable or more reasonable to charge a larger fee, for example, at a state Supreme Court than it is at a circuit court. And in a big city, you will probably get a higher legal fee than you will in a more rural community. So if you have two clients, Jim, who has a probate matter in circuit court, and Billy Bob, who is appealing a contract dispute to the Supreme Court, the more difficult matter is the one at the Supreme Court. Billy Bob's probably going to get a higher fee than Jim is because of the difficulty of the work. Similarly, if Jim has a case in rural Nebraska and Billy Bob has a matter in D.C. at the Circuit Court of Appeals there, the hourly rates for lawyers in D.C. are somewhat insane. There is something there called a Laffey matrix, and no, I am not making that up. You can look it up. And it's no laughing matter. A lawyer with my level of experience, 20 years or more, can reasonably charge in excess of $850 an hour in the District of Columbia. Now, I'd be lucky to get $200 an hour in Nebraska. So those two factors, location and matter, level of court, are just two of the factors that figure into any legal fee, in addition to the ones set out in the statute. But what are the types of legal fees that are available to a client? They are the flat fee, the hourly fee, the contingent fee, and the blended fee. All of these we'll talk about here in just a moment. Now, flat fees are most frequently seen in domestic relations cases and criminal cases. You have no doubt seen in the newspaper or other places ads that say, uncontested divorce $250, or something similar to that. Most lawyers would tell you that there is no such thing as an uncontested divorce. However, every now and then, a lawyer will come and meet with two people, one of whom he will determine to be the client, and the other will not be the client, because you can only have one client, and otherwise you would be adverse to the other. So one of them will be the client, one of them won't be the client, but they have agreed on how to split everything up. They don't have any children. There's nothing messy. They're leaving on good terms. They just fell out of love. The lawyer will be happy to do the paperwork for $250 for a flat fee because he already has all of that paperwork ready to go on his computer. And anyway, he just has to plug in the names and the addresses. But this kind of case is very rare. most of the time when there is a divorce, one party or the other wants to fight over something. It's just human nature. You've been with somebody for 4 or 5 years. You've now decided to get a divorce. The first stage is anger, and so you're angry at one another, and you say a lot of things you don't mean, and then one party decides that they can prevent the other party from getting something that they want, and before you know it, you're in circuit court fighting over who gets the cat box. This is not the way to run a railroad, but unfortunately, a lot of people do this in divorce, and it's crazy, and a lawyer has an obligation to them to encourage them to work cooperatively together to end the marriage so that they don't wind up ending each other's lives. And most of the time, when there is a divorce, that is a legal fee that is charged by the hour. And the reason that it's charged by the hour, frankly, is to make it painful and make it to the point where you get this thing done and you don't fight about it for the rest of your life. Or, as my boss once said, "Do you know why divorces are so expensive?" And I said, "No." And he said, "Because they are so worth it." And I think he probably has that right. Anyway, when they want to fight and they fight over something, the clock starts ticking, the meter goes down, and before you know it, you have a fairly large fee. Now, that's particularly true when infidelity has been an issue in the marriage, and the person who's been jilted will quite frequently want a pound of flesh as a result. And that's not just limited to women. I mean, hell may not have any fury like that of a woman scorned, but a man's scorn is doggone pretty bad too, let me tell you. But once you go beyond that $250 for the contested divorce, you are almost always in an hourly fee situation. In addition to having flat fees for an occasional divorce, many criminal cases are handled on flat fees. Usually these are simple domestic kinds of cases, domestic battery maybe, or an assault and battery between two people, something that is a misdemeanor that is not going to be a felony kind of case. So this is the kind of case where the lawyer actually does more work as a deal maker than a litigator and tries to work out with the prosecution an agreement that will terminate the case without causing too much harm to the client. And lawyers can usually be very successful at this, particularly if it's a one-off thing. This is not somebody who has routinely been involved in criminal activity. Well, then usually you can get a pretty good result with a plea bargain. And in the event that it goes to trial, well, then the flat fee is going to cost a little bit more. It's not going to cost the client anymore because he's agreed to the flat fee and so has the lawyer. But the lawyer's not going to make as much money in that situation. But in a simple case, a simple misdemeanor case, he can charge a flat fee of $1,500 and probably make a profit as much as $900 at the end of the day because he has to pay a secretary, he has to have an office, and he has to pay staff. So a lot of that $1,500 fee goes to overhead. But that assumes that he doesn't have to do any depositions in the case and that expenses are part of the flat fee. So once you get past a flat fee in a criminal case, once you have a serious felony, for example, something like the Donna Adelson matter or the Charlie Adelson matter, something like that, now you are not talking about a flat fee. You're talking about an hourly fee. And if you're going to hire private counsel to represent you in a criminal matter, you better be prepared to pay as much as $50,000 or more to get a good result in something like that. That's because they take a long time to get to resolution, and an attorney can every now and then work out a deal early, and a flat fee would still be a good deal for them. But in most serious felonies, you're not going to be able to work out a favorable plea deal. So in that situation, you're going to have to take the case to trial, which means you're going to have to spend many, many days preparing for it and getting ready for it and being prepared to cross-examine people. It makes the idea of an hourly fee much more attractive in a criminal case like that. And in a flat fee situation where the client rejects a plea offer, in that situation, the lawyer is going to demand a retainer and essentially tell them that they're now on an hourly case. And that's because it takes a lot of time, effort, and energy and money to produce a good verdict in a criminal case. For the last several hundred years, hourly fees have pretty much been how lawyers have billed for everything. However much time they worked on a file, that's how much time they billed to the file. Most law offices bill in 1/10 of an hour, or roughly every 6 minutes. And some law firms bill every 10 minutes, but most bill, I think, around 6 minutes at a time, in tenths of an hour. So if you are on a flat fee, you don't have to worry about it, but if you are on an hourly fee and you need to call and talk to your lawyer, you need to get your conversation done with in under 6 minutes so you don't have to spend as much money in hourly fees. A little tip I will pass on there. Some of the larger class action firms, however, bill by the quarter hour, so they get a 1-minute phone call, they bill it to the file, and it comes in billed as a 15-minute phone call. The same thing with reading an email. It comes up, it's 15 minutes spent reading that email. The fact of the matter is that most lawyers don't like hourly fees, and for the most part, many lawyers are very bad at keeping time. With the advent of the cell phone, this thing here makes it a lot easier for me to keep track of time because I have a program on it that I can punch a start button and punch a stop button, and it will automatically track the time. And there are time and billing software programs on both on the Mac and on the PC side that will do the same thing and run in the background and keep track of your time. A lawyer spends the amount of time that a lawyer spends on a particular file and how much work he does is something that usually goes into the system where you're billing for your hourly time. So an entry for a time entry might be 0.5 of an hour. Read the indictment, period. Made some notes, period. This is the legal research I plan to do. And then that goes into your time and billing software so that you know when you get ready to defend that fee, if you have to defend it later on, that you can show how you spent your time. But generally, even though I have the software to do that, I absolutely hate to do hourly billing. The next and somewhat more popular way for a lawyer to bill for his services is the contingent fee agreement. Now, in every state, the contingent fee agreement has to be in writing. You either send the client a letter, this is what our agreement is, or you draw up a contract and have them sign the contract so that everybody knows what the agreement is. The contingent fee agreement says the client will pay nothing to the lawyer unless and until there is a recovery of money on behalf of the client. So if Billy Bob sues Jim and gets a judgment for $2 million and then Jim declares bankruptcy and Billy Bob winds up getting nothing, the lawyer then gets nothing. True, the lawyer did get a $2 million judgment for Billy Bob, but if Billy Bob didn't actually get the cash, the check, and the lawyer doesn't get a check either. It just doesn't work that way. In that regard, it's a pretty good deal for the client. They essentially have a risk-free advocate. If they lose, they don't have to pay the lawyer. And contingent fees range between 33% and 50%. Now, I have never charged a 50% contingent fee for any case that I've handled. Our law firm's standard fee for contingent cases was 40%. Even that seemed high to me, but you have to realize what goes into a contingent fee. Not every case that comes in the door is a case we're going to win. There are all kinds of things that go wrong in a lawsuit. People forget to mention that little conviction for drug abuse in their past. Things happen that you're not aware of. There's video that shows that the accident didn't occur the way your client is saying that it occurred. And a lot of these things have occurred after you've spent a good deal of money on the particular case. You, meaning the attorney, has spent a good deal of time and money on the case. So those cases are going to wind up getting dismissed. And that has happened to me in the past. Boy, is that ever annoying. But all of the money and all the time that was spent on that case is gone. So the next case, when it comes in with a quick settlement for $3 million, the 40% fee of $1.2 million tends to offset the loss from the other cases. Plaintiffs' lawyers have to be very good at determining which cases are likely to come in with a result and which are not, because lawyers do not invest in cases they do not believe they can win. And if you think about it, that's really what it is. You're asking the lawyer to invest in your case, put his money into the filing fee, pay for the depositions, pay for the experts, and then get you a result. And they're not going to do that if they're not at least 95% sure that they can win in a court of law. Now, a lot of people will tell you that lawyers just take cases to settle. Well, good lawyers don't. I have never been in a situation where I have taken a case with the idea that I'm going to settle it. I have always taken cases with the idea that I'm going to have to go into court and work my behind off and get a result in court. And that's what I have routinely done over the course of my career. Unfortunately, for many lawyers, there are just a lot of times when the investment doesn't pay off. And that's one of the reasons why contingent fee work is very risky for a lawyer, particularly a lawyer who is just starting out. Of course, it's not just regular people who need lawyers. Corporations need lawyers all the time. For corporate clients, sometimes lawyers use an hourly rate, and sometimes they will do a blended rate. Most corporations are used to paying an hourly fee. They pay their litigation counsel an hourly fee, and that's negotiated between their general counsel and the law firm. If the law firm's regular rate is $350 per hour, you can bet that the majority of work is going to be done by associates who are billing at $150 per hour, and that higher $350 an hour rate will be reserved for partners who are going to probably be doing the majority of the work at trial. Because corporations can be a bit more mercenary in the negotiation process, and there's lots of lawyers out there who are going to be willing to get an hourly gig with an employer like that, a lot of times they can work for a lot less money that you can when you're working for a corporate client than you would a regular person just coming in for the first time. So in those situations, sometimes corporations will do what's called a blended rate. So for routine work, things like legal research, depositions, that sort of thing, the routine hourly work will be done at an hourly rate, maybe $100, we'll say, just to keep it simple. And then in the event that there is a recovery, or if it's resolved, if they're the defendant and it's resolved without any recovery, the law firm will retain a bonus of some specified amount. And if the litigation is unsuccessful, well, then the law firm gets to keep the hourly rate but doesn't get anything else. The blended rate tends to work out very well for corporations that have a lot of claims. Now, not every law firm is willing to do that, but many are. Now, we've discussed about half of the issues with legal billing, and I know what you're thinking. How can that be half of the issues? It can be half of the issues because you've been talking about fees here, and we're not talking about expenses. When a lawyer sues another party, they have to pay a filing fee. In addition to the filing fee, they got to drive to the courthouse, they have to park, they have to do legal research on either Westlaw or Nexus in preparation of the lawsuit. They have to pay secretaries and other people like that. They have to go get medical records when there's a crash or something like that. When they do depositions, those depositions cost between $300 and $1,500, depending on how long and how many pages they are. They have to go and get medical records, like I said. They have to order those. They have to pay for them. And many times they have to pay for an expert to review those medical records. And that requires a significant retainer between $1,000 and $3,000 that they pay to the doctor in order to get his response. And if he tells them, yeah, it's a case, then they go forward. Usually the doctor files a verbal report instead of a written report so that if the opinion is negative, then they always have the option of getting another opinion and they don't have to disclose that person as someone that they talk to. So that's the general story about expenses. In many cases, particularly medical malpractice cases and contingent fee situations, you might have a 40% fee and there might be another 10 or 20% that gets tacked on in terms of expenses just by virtue of what they had to pay to get the case ready for trial. So fees are different from expenses. Attorney's fees have to be reasonable. If they are contingent, they have to be in writing. If they are blended, generally speaking, they need to be in writing so that everybody knows what the agreement is. And even if they're hourly, it's always a good idea for your attorney to put it in writing. And that way you know how much you're going to be billed for whatever service you're asking the lawyer for. Attorney's fees and the way in which they are paid can be negotiated. If the lawyer says, I charge $250 an hour, and you say, well, I'm only going to be able to pay you $225, in most cases, a lawyer is going to be willing to cut his fee a little bit in order to get the business, unless he's just overwhelmed with work and he doesn't really want your case in the first place, in which case you say is $250 or hit the door. But in most cases, lawyers are willing to negotiate their fees and are usually happy to do so if it means they're going to retain you as a client. Specifically with regard to plaintiff's attorneys, if you have a serious personal injury case and a lawyer quotes you a fee of 50%, a contingent fee of 50%, you simply say, that's not reasonable. There are people who will do it for 40. If you won't do it for 40, I'll go find somebody who will. Or if you're in a particularly rural area of the country, you could probably get by with demanding 33 1/3. You need to be certain what a state's law allows a lawyer to charge. And you can usually find that information on the state bar's website. Expenses have to be reasonable. In other words, if you are traveling to do depositions, you don't stay at the most expensive hotel in town. You stay at some place that your client can afford to have you stay. So all of these things are tied to a rule of reasonableness. And there is also a program in most bar jurisdictions where if a client thinks they have been overcharged for a fee, they can go to mandatory fee arbitration or to fee resolution and work with the bar to drive the price down to a reasonable level. So that's what I have for you today. Thank you very much for watching. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff. And if you have the opportunity, please do something nice for somebody today. And then come on back, join me down here tomorrow. We'll talk about something else. Hey, as I said at the beginning, none of what I said is legal advice. But let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.